we're not here to minimize what this group has done for the community and the valuable service they provide the community. That's not what is at issue today. What is at issue is I'd like to remind the Planning Commission of what a special permit is to begin with, because this is something that you grant, okay? Now, you have the authority under Hawaii Revised Statutes, Section 205-6, and it allows you to permit certain unusual and reasonable uses within agricultural and rural districts other than those for which the district is classified. So the property that S.P.A.C.E. is occupying, or whichever entity we're discussing today, the space that they occupy, the property is zoned agricultural. So the reason they got a special permit to begin with was to allow them to do something other than agriculture, which is what is supposed to occur on state agricultural land. So now, when the Planning Commission grants these special permits, it's done, they do it, the law requires you to do it under such protective restrictions as may be deemed necessary to permit the desired uses. Now, back in September of 2001, the applicant came in for special permit. I'm sure you've all reviewed the transcript from the Planning Commission that granted the permit. It was based on representations made by the applicant. And I would remind you that this is only one representation made by the applicant at that time, was that, quote, "It is not our intention to hold public performances in this facility." Now, the reason the conditions that are on the special permit are on there to begin with is because it was based on what was represented by the applicant when they came in for the special permit. So when you come in for a special permit, you're expected to comply with those conditions. The only reason we're here today is because the applicant has been unwilling to comply with the conditions of the special permit number 1122, even though the planning director has given the applicant numerous opportunities to do so. The department has bent over backwards to try and help them comply with their permit. The planning director even allowed them to continue with their farmers market because she didn't want to see people be laid off from work, because they obviously are hiring people to work as well. But the other thing you have to consider is we're not here just about the applicant. This also includes the rights of surrounding neighbors. Okay, now the reason conditions are put on special permits to begin with is to protect the surrounding area. Now, so you cannot forget about the rights of the neighbors. And by the way, there was more than one person complaining. They've received numerous complaints over the years, and some very recent ones. Now, the planning director understands the contributions that S.P.A.C.E. makes to the community. She's not trying to discount that. She appreciates that, just like anybody would. But at the same time, why should S.P.A.C.E. be permitted to continuously violate the conditions of its permit when everyone else who receives a special permit is required to do the same thing, to comply with the conditions of their special permits? It's not fair to other special permit holders, and it is certainly not fair to the surrounding neighbors who depend on those conditions being enforced. The planning department is charged with enforcing the conditions of special permits. Quite honestly, they've run out of ways to do that, because every time they've sent a notice, it's been ignored. Even when the planning director went out of her way to allow them to continue to do the farmers markets, they still continued all their other activities, which is in direct violation of their permit. So the only reason, like I said, we're here today is because what else can the planning director do at this point? And she cannot revoke the permit. Only the planning commission can revoke the permit because the planning commission is the only entity that has the authority to do so. I'd like to also comment about some of the things that were made by the applicant and his attorney. The applicant could have avoided, they were talking about the legal fees they've accrued, but the legal fees that they spent for today could have been avoided by simply complying with their permit. And obviously they knew how to do that because they were at the planning commission telling the planning commission what they were agreeing to do and not do when they got their special permit. Special permit was based on what they presented, not what anyone else presented, not what the neighbors presented. And I would hate to even imagine how many hours it has taken for the staff of the planning department to respond to the complaints filed against what's been going on at this particular project. So you have to consider more than just what's been presented by the applicant. You need to also remember there are other people involved in this, and maybe they do not want to come forward because maybe they don't want to compete with this kind of crowd, but there are those people that have to be considered as well. So I think you need to...
Order. Stay with respect, please. Thank you.
I think that the Planning Commission needs to review the law and keep that in mind. And there's no doubt that the violations have occurred. On the other hand, if the Planning Commission decides that it's not going to revoke the permit, then and give them an opportunity to come in to apply for an amendment, which they've done before, and then they withdrew the amendment. But if that's what the Planning Commission is alternatively thinking about doing, then there should be some way to make sure that they comply with what's there now. I mean, there has been no compliance, so the permit needs to be complied with. It's still in place. Nothing changes that. Thank you. She wants to talk.
Okay.
Good morning, I guess, or is it possibly afternoon already?
Just about there.
All I've ever wanted is for S.P.A.C.E. to come in, seek an amendment to their special use permit, basically list what kinds of activities that they propose to hold on the facility over and above what they're already permitted for, and allow that to be in a process where neighbors and the community that they live in can suggest and ask the Planning Commission to put limitations. How many performances? If you're going to allow performances, how many? What hours? If you look at the current permit and the representations, the maximum number of people at any time at that facility was supposed to be 40 students and 10 staff, 50 people. The complaints that we've received have addressed parking issues, traffic issues, noise issues from more than one neighbor. And we seem to be here arguing over what the definition of a public performance is. For me, if it's more than the 40 students and 10 staff members, then it's moved into public, because the representation was that that's the maximum number of people at any time in that special use permit. The reason that that condition is there is because it's agricultural land, because it's in a subdivision with neighbors, you put those types of conditions on it. We have had other people with special use permits that have had violations, and we investigate complaints. Almost uniformly, we work with people trying to get them to comply, and we have a high success rate. You currently will have an application from Kalani Honua, which is going to the Land Use Commission, which is a result of our working with them to try and get some of the things that we do not feel are covered under their existing permits to become legally permitted. But when you have a situation where you have ongoing complaints from neighbors, the department is basically required to investigate those complaints, and if there's a determination made that existing activities are in violation of over and above what's permitted in the special use permit, then we have to do something about it. This is an unusual situation because I don't know that in my memory we've ever really come in to seek revocation, but basically it's because when we saw the advertisements for the Belly Acres and Lashik and other things that appeared to be occurring on site, they seemed to be public performances with donations sought that were not in compliance with the special use permit, and were resulting in an impact. And one of the issues of a special use permit is when you allow non-agricultural uses on agriculturally zoned land through a special use permit, there's always a representation made that it's not detrimental to the surrounding property owners, and in particular this subdivision. So you have to address parking, you have to address noise, you have to address maximum number of people at any event. And I suspect that if I were to open my home up to events on an annual basis or more often, where people were coming and I was soliciting donations for them to come to my house, and we had cars all over the subdivision, that my neighbors would probably be calling because I would be creating a nuisance to my neighbors. And so you have to have some mechanism for policing activity. You have to have some mechanism for ensuring that the neighbors' rights are not impacted. I happen to think this is a marvelous organization. I've seen many performances of the Hiccup Circus. I think they fulfill a need in the community, and an activity, especially for young children, that is welcomed by the community. I think they provide a valuable service. But it still means that if you come in for a special use permit on agriculturally zoned land, if you make certain representations about what your activities are, you have to comply with those representations. It appears that part of this is a misunderstanding between Mr. Ellis and his board as to what is or is not a public performance, as well as the department's understanding. And that may be a function of having to spell out more carefully in this and all future special use permits what constitutes a public performance, what is or is not a permissible use, and what type of maximum numbers of people you're going to expect. On farmers markets, it is a common misconception of people on agriculturally zoned land that a farmer's market is a permissible use on ag land. The only thing that's allowed is you can have a fruit stand or a vegetable stand or a McNut stand that sells the produce you grow on your property. You cannot have people come from other properties and sell what they grow on their properties on your property. For that, you have to have a special use permit. And the reasons are because of the additional traffic, the additional parking, the additional impact on the community. But it's a common misperception, so I can understand how Mr. Ellis would have thought that it was permissible, because it has happened multiple times on the island. And typically what people do is when we cite them, we say, hey, come in, get a special use permit, make it legal. And that's typically what occurs. They come through the process and make it legal. My frustration is that this has been more than 2 years since we started and said, please come in, amend the permit. And at some point, you have to try and get someone to move that process along more quickly, because otherwise, there's no teeth in the special use permit. There's no ability to ensure compliance. And so I have no opposition to giving Mr. Ellis some reasonable amount of time to get a proposed amendment together that spells out what it is he proposes to use the property for, what types of performances he's proposing, and then let the community, and particularly the surrounding property owners, have an opportunity, because they are the ones most immediately impacted by the traffic that comes in from outside of their subdivision. And so, it's up to the commission, because this is a commission action. But there also is going to need to be some, if there is a proposed future amendment, which Mr. Ellis is talking about and his representatives are talking about, it needs to clearly spell out what it is they're proposing to do, what are the maximum numbers of people that you're proposing to have there, what kind of mitigation are you going to do about noise and impact to the community, what provisions do you have for parking for the attendees. All of that has to be spelled out. So at any rate, at this point, it's up to the commission as to what you're going to do, whether you're going to go ahead and have people testify, or whether you want to propose some other way to handle this.